Want to welcome everyone here to our meeting. As of yesterday, we had 129 registered for the program, and so I'm sure a few more came in. And welcome all of you. Wish this was in person, but we understand under the circumstances it still has to be a Zoom meeting. I want to remind everyone that regular members are required to attend 2 meetings during the fiscal year, which runs September 2021 to June of 2022. There's only one more program after today, so if you're attending today for the first time, please be sure to attend the May program as well, so that you meet the qualifications for regular members. I want to thank all of our 2022 sponsors. They've been on the screen, but I want to mention the 5 platinum sponsors by names. We have Best Times Financial Planning, Inc., Mapstone Veritas, Tompkins Financial Advisors, Welker, Moshe and Delvecchio, and Woods Oviatt Gilman, LLP. If your company would want to become a 2022 gold or silver sponsor, please contact the EPC office or communications chair, Vicki Kleehammer at EFPR Group. Want to remind everybody to fill out the speaker evaluation form, which is part of the continuing education credit process. A link should pop up if you stay on the program at the end. This evaluation also helps us with upcoming programs. Keep in mind for the panelists, they'll not receive a pop-up link, so they'll have to get on and fill out the evaluation later on. For all the lawyers that are in attendance, keep in mind that you must enter the code numbers on the speaker evaluation form in order to earn continuing legal education credit. Our speakers will announce the codes during the presentation. Also, the attorneys must turn in the CLE board's revised attorney affirmation form, which is available on the EPC website. And to remind everybody, that's epcrochester.org. Here to introduce today's program is Lynn Carlton, CTFA, CSNP, AEP, Vice President and Trust Officer with Tompkins Financial Advisors, Western New York team, and also past president of the EPC. I want to thank Lynn for coordinating the program, and Lynn will now introduce our speakers.
Good morning, everybody. It is my real pleasure to introduce James and Nick today. James is a sibling advocate and a professional who has spent his entire career to create an organization for families planning for a disability. He is immediate past chair of the New York State Developmental Disabilities Planning Council. He is a member of the board of directors for the ARC of Monroe County, a member of the Estate Planning Council of Rochester, and the Society of Financial Services Professionals. James has earned his professional designation of a chartered special needs consultant, chartered life underwriter, and a chartered financial consultant. Nick has counseled clients with estates from tens of thousands of dollars to hundreds of millions. Whether it's protecting assets from nursing home, preserving multi-generational wealth, or dealing with legal complexities of a loved one's passing, Nick prides himself on helping his clients understand the legal issues they confront and working through their issues. Nick is a member of the Monroe County Bar Association and has chaired the Trust and Estate Council for the Bar Association for 2019. He was elected to Super Lawyers Rising Star list each year from 2016 to 2021, and he was awarded an up-and-coming attorney by the Rochester Daily Record in 2019, and named one to watch from Best Lawyers in 2021 and 2022. Their entire bios are in your material. Please read them, and I turn the program over to James and Nick. Thank you very much for presenting today. I know this will be a very good topic.
All right, thanks very much, Lynn. We also have great COVID beards. I wanted to add to the bios just for the, put that in the record. Okay, everyone, so I appreciate you taking a little bit of time this morning to hear about an introduction, emphasis on the introduction to special needs trust, as well as ABLE accounts. So the Estate Planning Council wanted us to keep things a little bit high level, and then I imagine in the questions we'll be able to answer some of your more technical questions. So we're going to also be focusing things on kind of the practical application of a lot of these differences and so forth. So specifically, The information Nick and I will be covering will be just a general discussion of benefits and why both of these planning vehicles are relevant and should be incorporated into your planning with clients. A general overview of special needs trust planning, the difference between the types of trusts that exist, first party, third party, and then pooled, which is really a subset of both first party and third party. General distribution considerations for special needs trusts. And then while we put ABLE accounts into just one bullet, there's going to be numerous slides on the topic, and we're going to discuss some practical applications of ABLE accounts, what makes up qualified disability expenses, information on qualified rollovers, and how it could also factor into your practice. Look at that, first code right out of the gate for you lawyers on the line. So the CLE code is 7473. So I'll give you a moment to make sure your pens are working. 7473. How much time do we need to give the lawyers to write down 4 digits? Nick, what do you think? Another minute?
If it's me, every other lawyer seems to have a great shorthand. Me, I might need another 10 minutes, but no, good.
Chisel it in there. Okay. If you don't know, I'll give it to you in the chat in a second. Okay. So I think for some context, I want to break down some false narratives out there. So you sometimes will hear in the media and even from professionals who have been in this space for a long time that the public benefits that an individual receives are so robust that a supplemental needs trust would only be used for things like a vacation or an iPad. And in our practice, we're seeing the need for essentially basic retirement planning for someone who's maybe 21 years or older and is going to live for 80 years. So, supplemental security income, which Rob Hilton was asking some questions in the chat about earlier, has a $2,000 asset limit. That number has not been indexed for inflation and has not changed in over 30 years, even though the benefit itself has more than tripled during that period. The benefit of being on supplemental security income is that it automatically makes the individual eligible for Medicaid. Medicaid being a health insurance program for people at or below the poverty level, or under the Affordable Care Act, it's been expanded to include different populations. But that is significant for 2 reasons. One, Medicaid is a health insurance that can either be in a primary position or a secondary if someone is covered under, for example, an employer-sponsored plan or their parents' employer-sponsored plan, even as an adult. But more importantly, in states like New York, it accounts for 1/3 of the New York State budget, and it is the mechanism that we have used to fund a variety of non-healthcare programs and services, such as the managed long-term care program to keep people out of nursing homes, the Office for Persons with Developmental Disabilities that supports individuals with intellectual or developmental disabilities, the New York State Department of Health programs that help individuals struggling with substance abuse, brain injuries, and so forth. So all of these systems are funded through Medicaid. So if you do not have Medicaid, you cannot private pay. There are some extremely affluent clients that are out there that have been forced, ironically, to get their children on Medicaid, not because they don't have the ability to private pay. And in fact, many of them would rather private pay. It's just the infrastructure for service delivery was not built to accept private dollars. It was built to accept Medicaid dollars. And the state will tell you that you're not allowed to supplant those benefits. You would have to simply forego them. So, we find in our practice that it's really the Medicaid that we're trying to preserve, and that would be the purpose of placing assets in either one of the different types of supplemental needs trusts or an ABLE account. And those resources would then be used to provide true financial support, because in New York State, the maximum amount of supplemental security income that you can get if you're not living in a certified group home type setting is $928 a month. So most of you couldn't pay your mortgage with $928 a month, and yet we're asking many of these individuals to pay for the entirety of their food, shelter, transportation costs, et cetera, and that benefit's simply inadequate. So the purpose of this type of planning is to give someone choice, to keep someone out of poverty, and allow them to maintain the quality of life that they're accustomed to. So kind of already covered the second bullet point here. The other thing is sometimes we hear, and this is just great for our practice, that, oh, it must not impact that many families. So according to the CDC and some of the most recent census data, there's 3.7 million New Yorkers that have a qualifying disability. That doesn't mean that all of them receive Medicaid. It's just that they meet the definition of disability. And there's over 500,000 New Yorkers that we've at least identified that cannot perform self-care. So if you can't perform self-care, typically, you're going to fall into a category where Medicaid as a service delivery system could be extremely useful in hiring personal care attendants, providing support so that you could live independently in the community. And if you look at then the demographics and the socioeconomic nature of our citizens, 511,000 is a lot of people. And so the majority of clients that people like Lynn, Nick, myself, Don are working with are those that have means, and they're just trying to plan for a family member that by the nature of their disability and their need for public benefits will not be able to have the assets in their name. And instead we want to plan for a lifetime of care for them after the family members are gone. So with that, I will be back after Nick does the special needs trust section.
Thanks, James. So we're talking about supplemental needs trust planning, and we're talking about how to preserve assets, and we're doing an introduction to those planning techniques. And so what I'm going to be covering in my portion is getting this stuff set up, getting it started, and most importantly, I think communicating it in a way to the client so that they can understand what it is that you're doing in an easy to digest manner. So it's very important, as James talked about, is to find ways in which to preserve assets that are flowing through the family to supplement these individuals with disabilities and their living standards. The particular language that you'll find with respect to any sort of supplemental needs trust in New York State is going to be derived from 7-1.12. And so you have language there that you can rely on in drafting. And I think what we really want to do is communicate to the client, trustees manage these trust assets for the sole benefit of the beneficiary, and by virtue of that, they don't count against the eligibility for government benefits, all of which James has gone over at a high level, I think, and what we're going to be talking about at a high level. So if you flip to the next slide, probably
I'm going to interrupt. I'm
ahead.
sorry, Nick, I'm going to interrupt just a moment. It says in our chat that it looks like you're muffled a bit. I don't know if you can move your your microphone. I would appreciate it. Thank you so much.
I'll hopefully sitting a little bit closer will improve your audio, albeit will make your video probably less attractive. The pandemic beard and part of it. So we're going to get up close and personal with special needs planning right here. And what I think, this diagram, while I think is probably somewhat below the level of the audience, is also, I think, very helpful to share just from the standpoint of preparation and explaining things to clients. Because there's nothing more gratifying in my experience than someone coming to the table, having been drinking from a fire hose for time and time again, trying to figure out where's up. And then they know that they're supposed to get a quote trust. and they don't even really understand the concept. And so this diagram is a diagram I use with clients all the time. You know, you can imagine in this type of area in supplemental needs trust planning, you're often talking with a young couple in their early 30s who haven't done any estate planning, aren't familiar with any of these concepts whatsoever, and they're trying to figure out what to do. And you know, they don't really understand what they're talking about from when they say, I need a trust, or we need to set up a trust. And so I always explain the very corny titled trust triangle to them so that they can get an idea of this conceptually and say, you know, look, really, you're familiar with a contract. You're familiar with the idea that you can make an agreement with respect to property. And that's really what you're doing. You as the settler, you as the person with property are going to enter into a sort of contract with the trustee, and it's going to be to oversee this trust property, whatever the money is that's there for the family, and it's going to be used for the benefit of the beneficiary. And in sharing that diagram with the clients, for a lot of people who maybe come to the table with a little less legal sophistication on these things, this really helps clarify and illustrate what it is they're doing, so it makes a little bit more sense to them as they start, you know, getting into what are a ton of nuances and rules and regarding supplemental needs trust planning. So I share this just as a helpful diagram if it helps anyone else in explaining this to a client. You can flip to the next one. Once you kind of establish the concept, the overarching concept of the trust with the client, next we want to delineate between the different types of trusts for the client in supplemental needs trust planning. And it's important to delineate between and distinguish between first and third party supplemental needs trusts. The first party supplemental needs trust is one where you're establishing it with the disabled beneficiary's own assets. So oftentimes this could come in form of like a personal injury settlement is a common one for that to happen, or you know, grandma, yaya, papa. In my, you know, we're kind of a mixed Greek and Methodist family, so we've got yaya, and we didn't quite get the papu. He stayed at the papa. But in any event, if yaya and papa don't make the right call with respect to their estate planning, and they say we really love our grandkids and we want to leave everything to the grandkids, and they do it and they don't think about these issues, all of a sudden there could be an inheritance there as well. And so those are some ways where you end up in a situation where the disabled individual has some assets, and at that point you're really focused in on first party supplemental needs trusts, which can be also subdivided into individual trusts and pooled trusts, which we'll compare a little bit more detail later in the presentation. The other type of trust is where yaya and papa do things the right way in their estate planning, and they say, you know what, my son's name's Levi, my daughter's name's Lila, so almost all of my examples end up being Levi and Lila, and my wife's name's Randy. So now that everybody knows my whole family, it's probably a little easier for you to understand where my names are coming from. But in the third party supplemental needs trust, you know, yaya and papa end up leaving things to Levi, who has a disability. They can set it up as a third party supplemental needs trust, where the third party is yaya and papa, third party to the disabled beneficiary Levi, and they're using it for their benefit, and they can set funds aside in a protected manner for it. So we can flip past that part. Now, at that point, you've lost the client, right? First party, third party, pool class, all this stuff, and they're just kind of getting, you know, bounce back and forth with all these things. And so what I really like to do at that point, from the standpoint of explaining this to the clients, is give them policy reasons. I was a history major. It was always easier for me to understand if I knew the why somehow, some way. You know, if we had to memorize the rules, I did get through law school, so I had to memorize some nonsensical rules. But if I could understand the why, it was a lot easier for me to contextualize all this. So I try to explain the policy reasons behind their existence. And for first party trusts, the government does not want to incentivize indiscriminate spending. And you can insert your joke there about the government's ability to budget and not indiscriminately spend at random. So with the first party trust, what you're really saying is, it used to be a situation before we had any of these type of planning techniques where you just say, oh my gosh, try to spend it down on whatever you can spend it down on as fast as you can spend it down on. That doesn't help in any way, shape, or form, and for anyone, government included. And that was recognized, and that's where the first party trust really comes into play to say, look, here's a way where we can incentivize people to stock the money away so that they don't indiscriminately spend. And by virtue of that, hopefully, from the government's perspective, there'll be a remainder that will be paid out to the government when all is said and done. On the third party trust side of things, you say, well, why would you be able to do that type of planning? Why does the government allow us to do anything like that? Well, they're also trying to disincentivize just disinheriting disabled beneficiaries. And so we don't want to be in a situation where the disabled individual all of a sudden is left out cold in the wind, because we, just like James was saying at the introduction, we don't want situations where people are falling into poverty. That causes other taxes on the society and everything else. So we've got these types of planning to allow us a way to, at least hopefully, manage money in a way that's a little bit more beneficial for all parties involved. And you can flip to the next one. Now, this is going to be the first of my, so now we've kind of in the client process, we've started the introduction, we've kind of laid out what a trust is, we've introduced them to third and first party trusts. And you kind of want a big picture at that point to come back and sum it up. And this is just what I think is a really great diagram that I've taken from Bogart's outline right there at that, and that's the link. And it'll be my first plug during the portion of my presentation for that outline, because I just can't say enough good things about the outline. I think they did a really, really good job. I think it's helpful for practitioners to really, when there's that concept that you've learned over and over again, but you seem like you have to go and relearn it again, it's a great place to get started. And for the, for your more sophisticated clients who are really trying to dig in and really understand the nitty gritty, I think it does a lot of good things. So at the end, we've got some useful resources for you, this being one of them. And if you don't have that saved away in your hard drive somewhere, I highly recommend it if you're into this type of planning. But I really like the way that it lays out first party self-settled versus third party. And then certainly, you can see for the estate planners in the room that, you oftentimes outside of the supplemental needs trust side of things get questions about revocable, irrevocable. I think it does a really nice thing there. I've got a raised hand for a question. I don't know how I answer it. But anyway. All right, so basically, this also allows us to, this diagram allows us to differentiate between where we are on that first party divide of supplemental needs trust. And that's at D4A, D4C, the blue and the green there, as far as using the individual versus the pooled trust, third party, and then the third party. So you can flip to the next one. So that brings us to delineating, differentiating between first party and individual trust versus the pooled trust. And so in some ways, at a base level, they're similar. So you're going to be funding this with the beneficiary's assets or income. So in that way that they don't differ, they're not different at all. They are created in a little bit of a different way. Well, it used to be that it was a little bit more difficult, and now has become a little bit easier to accomplish, because at this point we can now create a self-settled supplemental needs trust. The disabled individual can create it on their own, and we're not just limited to the parent, grandparent, legal guardian, or the court. We still have those cards in our back pocket if we need to as practitioners. But hopefully that simplifies things in a lot of different ways, and it really has. Now, on the pooled trust, it's a little bit easier. We would be looking at funding that trust and creating that trust by anyone with legal access to the disabled beneficiaries' assets. So if sticking with Levi, if Levi is turning 18, it would be very common to start considering and he has a disability such that he can't really manage his decisions. It would be very common to seek a 17A guardianship as he reaches the age of majority, so that I, as his parent, have access to his assets or access to his, more importantly, in most cases, access to his medical providers and being able to help make medical decisions for him. But that would be one way, or a power of attorney with gifting authority if the individual has the capacity to execute that power of attorney, in which case either one of those positions could then work with the pooled trust to be able to fund it. In the individual trust side of things, the beneficiary must be less than 65 years of age, whereas in the pooled trust, the beneficiary can be of any age. Both of the trusts are effectively irrevocable in that you transfer the money in, it's in. And in the irrevocable trust for the individual, it's for the sole benefit of the beneficiary, while and it's still the benefit of this individual beneficiary in the pool, but the remainder beneficiaries are a little bit different in both situations. And so the individual trust, the first party trust, requires a payback to the government on termination, whereas on the pooled trust, it just flows into the general trust pot, and then is there for the general use of the trust fund for the beneficiaries. Finally, the funeral may be prepaid but may not be paid after death. So if you flip on to the next slide, that previous slide is a way to visualize those differences and kind of explain the difference between the D4A, the D4C trusts being individual, being the pool. Then you come to the more common, I think, planning, which is around the third party supplemental needs trusts. And this goes right back to the young couple with the disabled child, and what are we doing here to try to protect the child that has disabilities over the long haul. And you explain to that client, look, you can create this trust outright. You know, you can make it on the one hand and say, you know, make that trust. We'll write up the trust, we'll set it up now, we'll get it all squared away, and that's fine. And the other way, though, is that you can actually draft up your will and on death have this trust come into being. Sorry, I leaned back. So sorry if I was muffled. You can do it in one hand or you can do it in the other hand. The big and important thing with respect to the third party supplemental needs trusts is that there's no payback provision on the trust termination, unlike those first party trusts we just discussed, where there's a payback provision either to the government or falls to the trust. Now, this is because, again, I like to go back to the policy reasons for the purpose of explaining this to clients. This is because we want people to be, you had no responsibility to pay this money over into this type of trust, either under an agreement or under a will. And therefore you should have the authority to be able to parse it out whenever it's been used for whatever it is that you want it to be used. So there's no payback provision on here, which is a huge advantage, obviously, of the third party supplemental needs trust. Now, the last bullet point, usually advise clients to create under will. The question is third party. What government review is he referring to? So with third party, I'm not talking so much about government review in the payback provisions, though that can be an issue. I'm really talking about the fact that when we're talking about trust law, you're setting up a trust to manage assets, and you had no responsibility. I mean, if Levi and Lila are there and I've got an estate plan, my responsibility at death with my estate plan could have been and could simply be to say, I leave everything to Lila and I leave nothing to Levi. And if that's the case, it doesn't help the government at all. And it certainly doesn't help Levi stay out of poverty or deal anything along those lines. And so, since I don't have a responsibility to leave anything to Levi underneath my will, the government, by setting up the ability to do the third-party supplemental needs trust, is effectively opening up an avenue where you can say to Nick, look, Nick, you can leave things to Levi, you can make sure your kids are taken care of, and you can know that your money's not just going to be paid over to the government when all is said and done. There's a bunch of government review that has to do with what James was talking about initially, about eligibility requirements and everything along those lines. But that policy conversation about incentivizing people, or not, I should say not, that's too many negatives in one sentence. Incentivizing people to take care of their children, take care of their loved ones, is really the government policy that is behind this third-party supplemental needs trust.
And one other
ahead,
point,
James.
John, is that the Department of Social Services and the United States Social Security Administration can also audit trust distributions and ask for an annual accounting. And what they're looking for is if the trustee has supplanted benefits that they have provided, thereby disqualifying the beneficiary. So there is time for the government to not only review the trust instrument, but also review the annual accounting. And often it is irritating, to say the least, because you have a layperson making broad legal comments, kind of like me right now. But it's if it's testamentary in nature and not funded, there's nothing to audit.
That's exactly right. Thank you, James. That's with that young couple, advising them to go under the will means there's nothing to audit, means that they have complete flexibility to change their will at any given time in the future, and is creating the safety net that they want, while also alleviating them from the burden of having extra legal procedures initially created. So thank you, James, and thank you, John, for the good question. Next slide.
There was one question that came through on the other Q&A panel, and it's from Rob Hilton. Can a third-party trust created and originally funded by the grandparents be the beneficiary and inheritance assets from another, say, parents? So yes, Rob, oftentimes that is the textbook example of when an inter vivos trust would be more appropriate, because if the grandparents want to leave assets to their grandchild, but the parents have a testamentary supplemental needs trust in their will, there is no trust until the parents die. So that would be an example where you create a inter vivos trust, you have it sit unfunded, the grandparents direct assets, and then the parents, assuming that they all agree on the remainder beneficiaries, could then also direct assets into that one trust, which from a practical standpoint, we like, because it's one less 1041, it's easier to administer. So Lynn in her team can administer one instead of multiple ones. It's just practically easier. But I want to emphasize that you want to agree on the same remainder beneficiaries, because that can sometimes create a little bit of a rift practically.
Yeah, I mean, real life example, I'm working with a husband, an ex-husband, ex-wife, and a sister, all of whom want to benefit ex-husband's son who has a disability. And so all three parties have worked together to basically say, okay, we're going to set up this lifetime inter vivos trust. And while I ramble on, CLE code 4206 is in the background, so we'll have plenty of time to write. But that gave the family the ability to all do that, and that was James was spot on. The main question there that we kept coming back to is who is going to be the remainder beneficiary, because you all really need to agree on who the remainder beneficiary is. So again, CLE code 4206. And then coming close to the end here, I think this may be my last slide. The trustee selection is huge. And in this type of planning, especially where I keep coming back to that example of the young couple with the young child, they're not quite sure, and they certainly don't have a good grasp of all that Lynn's team does with respect to a trust administration. It's a huge amount of responsibility. And so I always describe it to folks in a spectrum. And I say, look, you've got a spectrum of options. On the one side of the spectrum, you've got the individuals. And the individuals are great because they know the person and they're intimately involved with the family, and you trust them and you love them. Okay, so they're great for those things. They're not great because they have no idea what a 1041 is. They don't know what the benefits mean, and they don't know all the ins and outs of the technical side of things. So on the other side of the spectrum, you have banks, trust companies, etc., who have just unbelievable amounts of background and knowledge about how this stuff works from a technical perspective, but maybe don't know the beneficiary as well. And so what you want to do in explaining that to the client is just say, okay, here's your spectrum of options. What would make the most sense in your situation? And if we go the individual route, we need to make sure that there are people there to be able to put them in the right places as far as those technical aspects. If we go the trust company route, then we need to do something to allow the trust company to better understand the beneficiary, maybe a letter of intent or something along those lines to say, here's what's going on with this beneficiary. This beneficiary loves WWE. I mean, you just got to get them the newest wrestling stuff because that's what they love. That's what they spend all their time watching. That kind of thing where you get a better quality of life for the individual. That's the big thing about trustee selection is you've got that kind of spectrum. And probably the biggest issue in supplemental needs trust planning and the one that weighs most heavy is understanding the impact of the distributions. So if we flip to the next slide, understanding distributions from the S&Ts, you explain to the client, look, everything in this trust bubble is protected against eligibility. If it's in the trust bubble, we're okay, but you didn't put all this money in the trust bubble for it just to sit in the bubble, right? There's going to be peeling off of this money at some point. And when you peel that money off and you make distributions, that's where you need to be very careful that you're not doing anything that might interrupt the beneficiary's benefits. Because if you make distributions for the wrong things, it can count against them. Primarily, oftentimes you're worried about reducing SSI benefits, but as James mentioned, and I think is in fact the case, SSI is often the leader into the big into the big thing of Medicaid. So in any event, you've got to be careful about these distributions. And I think James is going to talk a little bit more about them later, so I won't dive too much into it.
And just to build on that, these are discretionary trusts. So sometimes trustees tend to worry about this impact on a benefit. And so if we think about just dollars, so if someone's living in a $3,000 a month apartment in New York City and they're getting $928 in SSI and the trust has $3 million in it, as a trustee, I am not concerned if they lose $300 a month in SSI if I pay that rent. And I can make that discretionary distribution as long as the trust instrument gives me the authority to do so, and wasn't written years ago where it does not allow the beneficiary or the trustee to supplant benefits. So for those of you that have been doing this for a while, you may want to look back at some of your documents to see, does the trustee have the discretion to supplant benefits if they decide that that is in fact in the beneficiary's best interest? But a workaround to these things would then be the ABLE account. So
James, if I can just say one thing about that last point, because it's a good one. If you're using 7-1.12 as your standard language, you will have that language that James was referencing. So make that, do start with that as your language.
Absolutely, thank you. And it's not in the federal statute, so the state one, it's great. So With ABLE accounts, so these are an expansion of the Section 529 College Savings Program. So as a 529, it is a municipal security. The concept is that assets held in an ABLE account are controlled by the individual with the disability. Okay, so unlike say a 529 college savings plan in which the owner could be a parent, a grandparent, another third party, an ABLE account, the owner is the individual themselves, which creates other logistical issues such as capacity. Is the individual under an Article 17A guardianship proceeding? And does that Article 17A allow for property guardianship? Because this is property of the individual with the disability. So sometimes it requires the guardian to go back to the surrogate and ask for an expansion of their authority. So the assets that are held in an ABLE account, like a supplemental needs trust, do not impact the individual's eligibility for either SSI, Medicaid, or a variety of other benefits like Section 8, food stamp programs, et cetera. In order to be eligible, according to the federal law, the individual must have a disability that has an onset date prior to age 26. So it doesn't mean that they have to set up an ABLE account before 26. It just means that they have to have a disability that occurred prior to 26. Once assets are inside the ABLE account, distributions are made for qualified disability expenses, which I'll get into in a moment, do not impact the individual's eligibility for these benefits, and there are some tax benefits that we'll discuss in a moment. So in summary, the assets inside the ABLE account don't impact eligibility for benefits. Distributions, if used for the individual with a disability and fall under the super broad umbrella of qualified disability expenses, do not impact eligibility. And the individual themselves can have access to their own resources, which is a departure from how a supplemental needs trust works, in which the beneficiary never has direct access. They may have indirect access, but never direct. All right, third CLE code. Please stay on for the balance of my presentation and don't just bail on me here. It's 1378, 1378. Give you a second. 1378. Okay, 14 minutes. Okay. In addition to serving as a vehicle that allows for the eligibility of benefits while simultaneously accumulating resources, assets held inside an ABLE account, because it is a sister law of the Section 529 College Savings Plan, assets held inside the ABLE account grow tax deferred, and distributions are income tax free. Now, that's not a huge benefit to individuals on public benefits because most of them don't pay income taxes anyway. All SSI beneficiaries by law don't pay federal income tax. So it's mainly a benefit to parents, grandparents, people making lifetime gifts that could actually take dollars that perhaps they're accumulating for the benefit of an individual with a disability and shift them into a vehicle that would then be income tax free. Contributions are limited to the annual gift exclusion, which has recently been increased to $16,000 per year. Now that is total. So in New York, there's a mechanism for the state to actually track how many distributions come in from multiple parties, and the aggregate of those contributions cannot be in excess of $16,000. In theory, could you set up another state ABLE account, and is there a mechanism to connect them? Likely no, but that would be out of compliance. So it is subject to an annual contribution limit of 16 grand. The first $100,000, and we actually have some clients that are approaching $100,000 with these things. The first $100,000 is exempt from SSI. And so what that means is, if you reach $100,000 in the ABLE account, you are still deemed eligible for SSI, but your benefit is suspended until the ABLE account drops below 100,000. So that's significant because by being eligible for SSI, SSI is a federal benefit, so you're automatically eligible for Medicaid. So even if they suspend the benefit, it does not mean you need to recertify for Medicaid through the local Department of Social Services. You maintain your federal status of being Medicaid eligible, which is simply easier from an administrative standpoint. In New York State, again, emphasis on state-specific rules, because this is a municipal security, you're allowed to have up to 520,000. So in speaking to the state comptroller, Tom DiNapoli, they moved the number up to 520. So the legislature simply didn't have to keep amending the law. And it's unlikely that anyone's ever going to get up to 520,000. And so that's the maximum. So your first loophole: contributions to Enable account are not tax deductible the way a contribution to a Section 529 college savings plan would be tax deductible from a New York State income tax standpoint. However, under the Tax Cuts and Jobs Act, you are allowed to roll over qualified 529 plans into Enable account until the personal tax changes sunset in 2025. Hopefully set to continue under the next administration, but that's anyone's guess what happens there. So in speaking to the Office of the State Comptroller, they will not recapture any state income tax that was deducted prior if you do make a qualified rollover. So we do have some clients that are making 529 contributions and then rolling it over into the ABLE account. The intent of this was that many individuals, perhaps when their children were young and they didn't know the developmental trajectory of that child, were aggressively funding 529 plans only to discover that their child is not college bound. And this allows a mechanism to, in $16,000 intervals, shift money from a 529 into an ABLE account without incurring ordinary income tax or the 10% excise tax. The New York State ABLE account, or any, most ABLE accounts do also have, like a self-settled supplemental needs trust, a Medicaid lien on the trust. So in the event that the beneficiary passes away, to the extent the state has provided services, and they definitely track, we've asked for accounting before, they definitely track how much money they've spent. The state is the first, I guess, lien holder, you would be paid back first before any additional funds would be distributed to the beneficiary's estate. From just a general mechanics, the ABLE account, if the individual does control the account itself, there's a debit card option for them to access money that's in the cash account. So because these are accounts that can be invested, if you have invested resources, you can't, use the debit card and pull from the aggressive fund. It would need to be funds like a brokerage account inside the checking option. The debit card connects to the checking account, and then you can move money from the investments back into the checking and vice versa. So there's a debit card option, there's a checking account option, and in New York, there are 4 investment options: aggressive, intermediate, moderate, and conservative. The checking account is FDIC insured, and I believe Fifth Third Bank is the custodian. There was a question from John. ABLE payback, is the payback limited to what's left in ABLE at death? Yes, John, they can't go after other assets, and the payback would be limited to, my understanding is benefits that the state has provided. So in a situation where a beneficiary never had any benefits, there is no lien. Similar to a self-settled supplemental needs trust, if there's $1 million in the trust and the beneficiary only had 100,000 of benefits, the state is only entitled to 100,000, and that 900,000 could in fact go to remainder beneficiaries. Dave Urban asked, can an individual have more than one account? It's a little bit of a gray area. I believe the individual is supposed to have only one account. I do not believe there's a mechanism for the government to communicate within states. However, different states report on a monthly basis the assets inside an ABLE account, as well as distributions to the United States Social Security Administration. So if they're on SSI, there is a record that they have ABLE accounts, and I imagine it would be caught if there were multiple ones. However, if someone's not on SSI, I'm not aware of any mechanism to track this. So in theory, someone may have one. I think as a best practice, you should encourage clients to just have one ABLE account. It is possible, some states do allow the transfer from, say, the Ohio ABLE account to New York as a qualified transfer, like to like, without incurring any income taxation. It's a good question. Qualified disability expenses. So in 2020, the IRS finally gave their final guidance on what a qualified disability expense is. I've listed the link in the materials as well as the outline we submitted. If you ever want to see an abdication of responsibility, read what the IRS said. They basically said, as long as it's for the individuals increasing their quality of life, maintaining their health or independence, that is a qualified disability expense. So in the comment period, when they were putting together the final regulations, families were asking, can you please be more specific? And the IRS specifically said, no, we want you as the taxpayer or as the guardian to determine what a qualified disability expense is. And as long as it maintains health, independence, or quality of life, it counts. So under that definition, virtually any distribution would fall under a qualified disability expense. So New York State defines it as to include but are not limited to education, housing, transportation, employment training, assistive technology, personal support, healthcare expenses, financial management. In practice, we have clients that are using it to pay rent, to buy food, to pay RG&E bills, to pay car payments, pay car insurance, clothing, vacations, cat food, dog food, you name it. Virtually everything could be argued to be increasing independence or quality of life is really the one that we are relying on. So I wanted to emphasize food and shelter because if a supplemental needs trust were to pay for food and shelter and the individual were eligible for SSI, they would experience a 1/3 reduction in their SSI because food and shelter is really the intent of SSI. So if you're supplanting food and shelter, SSI lowers your benefit. However, if a qualified distribution comes out of an ABLE account for food and shelter, there is no 1/3 reduction. So we have lots of clients, especially that live downstate, high cost of living parts of the state. We have parents making $16,000 transfers from their own checking account into an ABLE account, and then immediately using the ABLE account to pay rent, to pay for food, et cetera, and the individual doesn't experience a 1/3 reduction in their SSI. So hopefully what you're starting to see is that ABLE accounts really complement supplemental needs trusts. They are not a replacement for a trust because they're not an estate planning vehicle. They're more of a practical working capital account as opposed to more of a large, long-term estate planning vehicle.
James,
Yes.
one question. Can the custodian parent use the ABLE account to make child support payments to another parent?
Typically not. So usually child support payments need to be to the parent. And because the ABLE account is an asset with respect to the child, the court, typically family court, again, I'm not an attorney, but would frown upon that. That's a great point though, because child support, which is now extended until age 26 in New York State, if you have, if you can prove disability, child support is deemed to be income with respect to the child. So between ages 18 and 26, that income would impact SSI and Medicaid. So a workaround to that is if you get a family court judge to order that the child support be paid to a self-settled supplemental needs trust, it needs to be ordered, it can't be voluntary, then it does not impact SSI. Medicaid, you can voluntarily contribute it, but for SSI, it needs to be under court order. And so the ABLE account is not useful for that child support and is also not useful, we'll get into another slide, for a Medicaid spend down. For a Medicaid spend down, it still needs to go into a self-settled supplemental needs trust, even though they have that common characteristic of having the Medicaid lien.
One more
All right.
question. Can a
You
New
bet.
York ABLE account support an individual living outside of New York State?
That's a great question, and absolutely. So the state-specific nature of the account it doesn't matter. You could live in a different state, and in fact, you could live in New York and set up an Ohio ABLE account. And actually, we have clients that did just that because New York was a little bit slow to adopt the federal regulations and come up with the New York ABLE account. There were other states that set it up prior. So we have a number of people that were early adopters and have Pennsylvania ABLE accounts or New York ABLE accounts, and there's no impact. There are some other states, if you work outside of New York, there are some other states that do extend the state income tax deduction for contributions into an ABLE account, but New York does not. All right, sorry, I'm moving a little quickly here. Just a couple more slides. Differences between the two. So typically with a special needs or supplemental needs trust, you're going to have higher costs to establish. You know, all the good teeny attorneys here, you know, you don't work for free. You know, we see costs between $1,500 and $4,500, you know, across the board that practitioners are charging. Closer you get to New York City, higher the fees. Special needs trusts, whether it's first party or third party, have no contribution limit. So you're not subject to that arbitrary $16,000 annual exclusion. You can either fund special needs trusts during lifetime if they're inter vivos or at death in a testamentary fashion. You can hold all different types of asset classes, real estate, you know, municipal securities, qualified funds, although that you shouldn't do that personally. With a third party trust, there's a remainder beneficiary. So you could provide for multiple generations. As I mentioned, self-settled trusts can be used for Medicaid spend down to allow someone who has excess income to qualify for Medicaid, whereas an ABLE account cannot. The individual cannot access their own money. So could you give them a credit card and then the trust pays the credit card? Sure. There's other vehicles that people in this space use called a TrueLink card, but in practice, the individual is the beneficiary. They can never be their own trustee. Contrast that with an ABLE account. So the ABLE account has a $16,000 annual contribution limit. I should say that if the individual is working and is not able to participate in an employer-sponsored retirement plan, they can actually contribute in excess of the $16,000. It's about another $12,000, so a total of $28,000 annually. But it would only be if they're working and they're contributing their own funds into the ABLE account, kind of like a quasi-defined contribution plan. The growth is tax deferred. They are subject to that lien. There are very low annual expenses. So with the New York State ABLE account, if you choose electronic statements, I believe the quarterly fee is $11.25. Contrast that with, you know, a financial advisor's fee or a professional trustee's fee. I mean, you're not going to beat $45 a year. In New York State, just like there are two custodians for the 529 plan, there's the advisor guided plan, which is through JP Morgan Chase, and then there's the state option, for lack of a better term, which is administered through Vanguard. The ABLE account looks exactly like the New York State 529 plan because it's essentially a mirror image. The platform's the same, and they use Vanguard as the funds. The individual can access their own money. So again, if the individual is not their own guardian, this creates just a little bit of a burden because you would need to petition the surrogates court to ask for guardian of the property or modify an existing 17A guardianship. And New York State will not allow the creation of an ABLE account for someone who does not have capacity if you don't have the authority to do so. So do we have parents posing as their children to set up the accounts? Sure, you know, we have that, but in practice, if someone is not their own legal guardian, you need to have the authority to create an asset. And as I mentioned earlier, the ABLE account does not create that in-kind support and maintenance issue or that 1/3 reduction. Okay.
James, I have another question.
You
Can
bet.
can two disabled individuals be beneficiaries of a single third-party SNT?
Tom, so there are, again, as a layperson, and maybe Nick can jump in, we have seen practitioners draft like pot trusts that do have multiple beneficiaries. As someone in this space, I frown upon that because I think it creates an undue burden on the trustee to make the you've got a situation where the intent of the trust is really to benefit one individual. So what if one sibling or one person has a much higher need than the other? You are in the impossible situation of trying to balance not only multiple beneficiaries, but then perhaps remainder beneficiaries as well. So I would strongly encourage you to have multiple supplemental needs trusts to have one beneficiary, even though technically you with a third party trust, we have seen, multiple beneficiaries. Nick, I don't know if you want to add to that.
I guess I would, I'd just use kind of a loose analogy to an LLC, because you're kind of creating more risk, right? You have the real estate person, they're putting multiple properties in the LLC. Eventually the risk of audit and all that other stuff comes into play, and you've created more risk by virtue of having more beneficiaries, more distributions, more things for that person who's the lay person to then come in from the government review side of things and then audit. So while you could technically maybe pull it off, the idea of bifurcating the risk or window painting the risk and having them in separate accounts makes more sense for simplicity purposes and for lowering that risk of saying, okay, well, what was going out here? Why was it going out here? Does it impact the other beneficiary? Anything along those lines?
So there was a question that came in about third-party S&T owning real estate and whether or not that would be considered in-kind support. Typically, that would be considered in-kind support because the trust is providing for housing. I think it's important to understand the fact that many times, by the time these trusts are funded, being funded at death, if the SSI beneficiary was disabled prior to 22, it's likely that they're going to be eligible for a childhood disability benefit, or otherwise known as a DAC benefit, off of the parent's record, which does not have the in-kind support and maintenance issues. So for most of our clients that have trust-owned real estate, they're not on SSI. But to answer your question, if the trust owns real estate and is providing housing, even though that trust is for the benefit of the individual with a disability, that is going to be considered in-kind support, and you're going to have the 1/3 SSI reduction. Any other questions? 9:21, trying to speed it up for you guys. While we're answering, there's some great resources. So for those interested in ABLE accounts, there's the National ABLE Resource Center, which is a nonprofit that compiles all the different states onto one place. I included the IRS guidance on qualified disability expenses, and you can laugh at how they abdicated their responsibility of giving specific guidance. Nick's outline for the SNTs from Valerie Bogart, who's a rock star in this space that many of us look to. That's the Western New York Law Center. Just general information on SNTs and as well as upcoming Medicaid changes. And Nick included a list, kind of an informal list of a lot of the pooled supplemental needs trusts. Something to just add on that is if you have a beneficiary that is going to be inheriting $10,000 and that's it, oftentimes people will lean to a pooled trust as opposed to spending $4,500 to draft, a supplemental needs trust. It isn't really prudent. Any other questions here?
I don't
Well,
see
without
any
any other
right now.
questions, I'd like to thank everyone for attending there. Lynn, thank you for organizing the program. And James and Nick, thank you so much for such a very informative presentation and for the use of your time and all the additional resources that you've given us in this area. It's always helpful to see the comparison and why you would want to use one over the other or a combination of both. And also reinforces my need to make sure I seek outside counsel as well, such as the Upstate Special Needs there or some other attorneys like Nick that are familiar with this area. A small token of our appreciation is going to be mailed out to both of you. Usually it's a gift card, but based on James' comments in the beginning, maybe it's a beard trimmer that we should be sending out or something.
Beard oil.
Although
Don.
you both look pretty good there on online there, so I don't think you need that. Just want to remind everyone of our upcoming annual meeting, which will be on May 25th at the Genesee Valley Club. We're going to try to do an in-person meeting there, although we're going to keep an eye on the public health needs. Hopefully there's no more additional variants coming up. But in the meantime, we do have a networking event scheduled as well for April 21st, 2022. Those of you who may have attended last year, we had a event with the Rome Cafe where you pick up your dinners at the Rome Cafe, and then we have a networking event, and everyone is spread out into random chat rooms. So you have a chance to speak and network with your fellow EPC members. Hope to see all of you there at the April 21st meeting, as well as at the May 25th meeting, which hopefully will be in person. We're going to try that again if we can. Again, don't forget to fill out your speaker evaluation forms, and for the attorneys, there's also the attorney affirmation. And I believe that in the chat area, there's links to both the speaker evaluation form, and you can also go to the attorney evaluation form as well. Thank you for attending.
And the presentation is on our website, on the EPC website, so you can print it and save it. I had a question on that, Don.
Okay. Thank you. I printed it while I was listening as well, too. I hopped on it. I made sure the attorney affirmation was also on the same page there, too. So. Thanks again. All right. Take care now.
Thank you.
Thank you.